women is a very sensitive topic, and when you are dealing with it, and especially as a lawyer, you have to be very careful because you are not dealing with that woman. You're dealing with the woman's children, the in-laws, the parents, the complete two families. It is in your hands either to bring them together or to separate them amicably and gracefully. But it is not possible always. I do understand there are some matters which are beyond explanation and beyond some understanding. Why people are behaving like this is totally an answer I will not be able to give to anybody. So sometimes the separation is the best part, but it's not always true. So whenever a woman approaches you about any kind of violence, it may be domestic, it may be physical, it may be emotional or mental. You have to always remember one thing, that try to understand actually it's her mistake, or it's actually she's exaggerating, or there is a possibility that she has been tutored by somebody, or there is undue influence of her parents on her. So try to understand and never be in a hurry to send the notice to the in-laws. It is my request, because in lot of matters where there are children born from these marriages, they suffer. Not only the parties suffer. If the parties are young and they have decided that they mutually do not want to continue, that we can understand. But sometimes it is actually next to impossible to get them together and also to get them separate, because whenever a lady separates, she wants her alimony because her rights of inheritance are clipped. She will not be a wife no longer, so she will not be getting the property rights as a widow, or as a wife also she will not be entitled to any many other things. So she will not be a wife, so she is cutting her clipping rights, clipping her ancestral rights. So always the inheritance rights are cut. So always remember, you have to explain that. Secondly, the lot of women comes to me, they say I want to go for divorce, but if I ask them where are they going to stay thereafter, they have no answer. They think that the court will provide the maintenance, but to prove the maintenance amount equivalent to which she can decently live in a society in a high inflation rate of today is next to impossible, because court may or may not grant the maintenance. And even if it grants, it only grants on the papers which is available before you. You may be saying my husband is very rich person, he has two houses, three houses, but then those houses are in the names of some other in-laws, and in his name only there will be some small property, or there may not be property is not even divided. In such cases actually it is really difficult to get good maintenance. So always remember, whenever a woman comes to you, just try to find out, explain the reality to her before going into legality. The reality picture has to be shown to that woman, that she has children and she has to grow them up. And secondly, even if at all she wants to separate, then the 498A, that is filing a police case is the only option. Just ask that, because after filing a police case, it's not meant for bringing a pressure on the husband, because that even court understands nowadays that just bringing pressure on the in-laws will not bring any yield, any profit or any money to her. So why we should always see from all the four corners which is useful. Whenever a lady comes to me, if I'm telling for myself, I try to evaluate all the situation, whether she has property she can survive on her own, whether she is an educated woman, whether she has a house or rights or in the house, whether her name is there in the property, whether she has a stridhan. The best thing I can do for a woman as a lawyer or you, that at least tell her to get her stridhan before she leaves the house, because afterwards the in-laws may say that she has already taken, then there may not be proof, there may be lockers in her name, there may be bank account. Tell her to take all the way. Sometimes I see women are struggling, the mothers are struggling even to get the certificate of their own education and the children's birth certificate. And they are unable to put their children into school also because they don't have the birth certificate. Sometimes there is transfer certificate that if children are grown up, the schools does not give the living certificate because there are father and mother both, unless and until they come together. So these are the all things you have to keep in mind. So just to file a case, domestic violence case, 498 case, maintenance case is not a solution. You have to think what is good for her, and number two, whether any step taken legally will help her. If there is no such cruelty and amount at a level, which is that she cannot leave, then you need not file a police case. That is my personal choice, because my personal opinion, in fact, that filing a police case maybe will increase the rift between two parties, and then it is very difficult to get settled. Sometimes people say that when there is a police case, it's good to build up a pressure, but nowadays, because of Arnesh Kumar judgment, there is no arrest in those cases. So there is no question of building pressure. Number two, even courts understand that if there are no facts available which shows the cruelty, they may not be convicted. The conviction rate in 490 case is just 3% if you survey it on the Google. So it is of no use unless there is a cruelty which is a level where she cannot live her life. If she can go to her parents' house and live a peaceful life and ask for maintenance, file a maintenance case. Number one, I'm not saying that she should depend on her parents, but if she has no her house, and instead of taking a step which is detrimental to her and her children, it's better that she separates from that environment which is causing cruelty to her and her children. Number two, we can file immediately she comes. The first guidance should be that she should collect her Sridhan, then only go to the court. Collecting Sridhan from the court after some time is actually really difficult, because when we come before the court may or may not decide the Sridhan application immediately, because the other side will not be kind enough to say that I have this Sridhan and I should give it immediately. There are very few people. In my cases, whenever there is, even if I am for a man or a husband, I'll tell, if it is her Sri, then you are not going to wear it, kindly give it. At least that will subsidize the matter, and the parties may come for settlement. Secondly, file a maintenance case immediately. If she is not earning, she has children, because the maintenance will be awarded from the date of application. आप जितना लेट करोगे उसको इतनी तकलीफ होगी. You are losing 1 or 2 months when you take time to file the maintenance case. And for maintenance, it is not that you have to you have to find out everything. You have to just find out whether husband is earning, what is the requirement of the wife and the children, whether children are school going. It doesn't require much of your efforts. Only reading few judgments under section 125 CRPC or Domestic Violence Act or Hindu Marriage Act can solve the problem. Sometimes I see uh, filing for maintenance in all the 125 CRPC, domestic violence case, Hindu Marriage Act. See, filing maintenance for in all the three cases is actually putting that woman into trouble for coming 3 times to court in 3 different cases. Instead of that, it's better we file one case where we get the amount of the maintenance, where we can bring all the facts together, not file 3 cases. That is a burdening of court, but with all 3 cases for the same maintenance case. Secondly, also burdening this lady with the children to go through 3 cases, pay a heavy fees for that, and also to waste time. And even her husband is, in a way, we are harassing the husband also for calling for 3 cases. So it's a waste of time. See, we are handling a family. In a 490 days, you cannot always say that I am only for the woman. You are in fact representing a family, and you should take care of the both the sides if possible. And court appreciates when you are fair to the other side as well. So family matters has to be handled very sincerely, with sensitiveness, and also with all the care. And when, especially when there are children, we should not come in the access of the way of the husband and wife, mother and father. If the children are ready to go, and if they are not ready, it is our duty to tell the our clients that they should. I see whenever a woman comes that she wants huge maintenance from the husband, but if the husband asks for the access of child, she refuses. If there will not be any contact between the children and the husband, where is the question of he giving good or he be being generous with the maintenance? In fact, you are establishing a communication line with the husband through your children. This is my explanation to all the women, because there may be fights and quarrels between the husband and wife, between the spouses, but there is no divorce granted to the children ever. So always remember, if the children are minor, it will be very nice of you and kind of you, and even court appreciate when you do not refuse giving access to the father. That is also, if the father is asking access, it's better to give, and that starts your communication line with the husband. So this was beyond law today, but whenever a woman comes to you, before you go to the step where you have to file legal case, you have to think of all this. from all the corners of the square and see what is good for your client. It's not just jumping and filing 3, 4 cases, bringing the husband to the knees and in-laws to knees will not solve the problem. Then it may go for 5 years or 10 years, and the young years of the both the parties are wasted in the court. So always remember, whenever a woman comes or even a husband comes, our first duty is to counsel, to become a father and mother. I always say that lawyer has to become a teacher, guide, philosopher, mother, father of the client. If that is the way you can handle the matter, let me tell you, even the judges and opposite lawyers will appreciate you, and you will be, in fact, a tool to solve the matter as early as possible. So this was about the violence against women, but in a different note. Thank you so much. And now I'll move to the reading part with Shilu. Shilu, kindly unmute yourself. Now this is a judgment of the Supreme Court again today. Now this is the bench of Swatantra Kumar and Madan Lokun sir. Now I'll read the first para. The present appeal is directed against the judgment of the High Court of Uttarakhand at Nainital, dated 14 October 2008, while which the High Court confirmed the judgment of the trial court and dismissed the appeal preferred by the accused against their conviction and order of sentence. Now, here I would, those who are students, I would like to attract your attention to the words used by the in the first para. The present appeal is directed against the judgment of the High Court. See the words, how the opening is. Then secondly, High Court confirmed the judgment of the trial court. When High Court upheld the trial court judgment, the word used is confirmed. Then dismiss the appeal preferred by the accused. See, preferred by the accused. These are the words you should be using when. That is the reason I always request that start reading judgments. It will improve your legal vocabulary. Now I'll ask Shilu to read from para 4. This will give you an idea about how the injuries are taken at the police station and how they how the trial goes on. In fact, that is my thrust. शिलू आप है ना पैरा 4 से पढ़ना शुरू कीजिए.
After Devendra Lal succumbed to his injuries in the hospital, a report was sent to the police. Sub-Inspector Daya Ram Singh, prosecution witness 8, came to the civil hospital, Haldwani, took up the charge of the dead body and prepared the inquest report, Exhibit A6. Whereafter, the body was handed over to Dr. T.C. Pant, prosecution witness 7, with a request to perform post-mortem upon the body of the deceased. The doctor performed the post-mortem and prepared a report, Exhibit A7, in which he noted the injuries upon the bodies of the deceased as well as the cause of death, which reads as follows. Prosecution witness 1.2 centimeter by half centimeter on the front of sternum, 7 centimeter middle left nipple. On opening of the wound, it is cavity deep piercing the sternum. Prosecution witness 8 centimeter by 3 centimeter into cavity deep on right side of the chest, 3 centimeters towards right nipple. On the opening of the wound, right lobe of the liver is cut. Prosecution witness 15 centimeter by 5 centimeter into cavity deep. Medial end of the wound touching 6th thoracic spine extending to the right side of back of chest. Right lung beneath the injury is cut. Punctured wound 4 centimeter by 3 centimeter into cavity deep 3 centimeter above from the left anterior superior iliac spine on left latitude side of abdomen. Loops of intestine coming out. Prosecution witness 3 centimeter by 1.5 centimeter into cavity deep around 3 centimeter. From left nipple underneath the injury. Left lung is cut. 4 centimeter into 2 centimeter into muscle deep on medial side of right knee about 2.5 centimeter from upper border of patella. 3 centimeter into 1.5 centimeter into muscle deep around 2 centimeter lateral to left anterior superior iliac spine. Prosecution witness 9, Sub-Inspector Ram Baran Ram, interrogated the witnesses, inspected the torches of the complainant and witnesses, prepared memorandums, Exhibit A2 to Exhibit A4, the site plan of the place of occurrence, Exhibit A10, arrested the accused persons on 15th of March 1991 and recovered the knife used in the crime upon the statement of G1, White Memorandum, Exhibit A. The report was filed in the court of competent jurisdiction. The accused persons were committed to the court of 3rd Additional Sessions Judge Nainital and were tried under Section 302 of Indian Penal Code, read with Section 34 of Indian Penal Code, the offence with which they were charged. The Learned Trial Court, by its judgment dated 25th of February 1994, formed the view that the prosecution had been able to prove its case beyond reasonable doubt and therefore convicted the accused persons of committing an offence under Section 302, read with Section 34 of IPC, and awarded them the following sentence. On the basis of the above evidence and circumstances, I arrive at the conclusion that the prosecution has succeeded in proving the charges leveled by them. Thus, I find the accused persons Jeevan, Kamal, and Dalip guilty for the offences of murder of Devendra on dated 12th of March 1991 at 10 p.m. in village Dhapla, Police Station, Kaladungi. Signature by Vijay Indra Singh, 3rd Additional Session Judge, Nainital Camp at Haldwani, dated 25th of February 1994. Order. The accused persons Jeevan, Kamal, and Dalip are found guilty for the offences under Section 302, read with Section 34 of Indian Penal Code. They are on bail. Their personal bonds and bail bonds are cancelled and the sureties are discharged. They be taken in custody for undergoing sentence to awarded after hearing them on the quantum of sentence. Signature by Brijendra Singh, 3rd Additional Sessions Judge, Nainital Camp at Haldwani, dated 25th of February 1994. I have heard the accused names Jeevan, Kamal, and Dalip and their learned counsel Sri Shyam Singh Mehra advocated on the quantum of sentence, who has stated that the accused persons are innocent, but I have convicted them after analyzing the evidence. Aggrieved from the judgment of conviction and order of sentence, the accused persons referred a common appeal before the High Court, which came to be dismissed by judgment of High Court dated 14th of October 2008, giving rise to the present appeal. It is contended on behalf of appellants or accused that the presence of prosecution witness 2 and prosecution witness 3 at the place of occurrence is very doubtful on the one hand, while on the other, as per the case of prosecution, the incident occurred near the place of marriage, where obviously a large number of persons must be present, and non-production of any such person from the marriage party raises doubt towards the case of prosecution. There is inordinate delay in filing the first information report. The occurrence took place at about 10 p.m. on 12th March of 1991, whilst the first information report, Exhibit A1, was lodged at about 8:45 p.m. on 13th of March 1991. Thus, the accused are entitled to the benefit of doubt. The inquest report is in contradiction with the medical evidence and the ocular evidence of prosecution, and there being material contradictions, The appellant is entitled to the benefit of acquittal. The accused person had not been given proper hearing before the High Court, and their right to a fair defense stood denied. Amongst the other contentions, we may deal with the last argument raised on behalf of the appellant at the threshold. There is no merit in the submission that the appellant was denied proper and fair hearing before the High Court. The accused had filed an appeal before the High Court through private counsels, Mr. V.S. Pal and Mr. V.S. Pal, advocates. These advocates appeared and took several adjournments before the High Court. Thereafter, they did not appear in that court. Then, Advocate Shri D.N. Sharma, appearing for appellants, stated that he had no instructions in the matter. The High Court have been left with no alternative but to proceed with the matter, and keeping in view the judgment of this court in the case of Dharampal versus the State of UP in year 2008, heard the appeal with the assistance of amicus curiae appointed by the court. Having heard both the amicus and the court counsel, the court then decided the appeal. The appeal was decided by the court in accordance with the law. These facts have also been recorded by the High Court in its judgment under appeal. In the grounds of appeal raised by the appellant, there is no challenge to these facts. Thus, in view of the undisputed facts, there is no occasion for the court to return a finding that the appellant had no proper opportunity of hearing before the High Court. The contention that the amicus curiae did not raise all the relevant contentions before the High Court is without any substance. It is not for the court to require a counsel, amicus curiae, to raise a submission. The submission may vary from counsel to counsel. The duty of the court was only to ensure that the accused was not held guilty without affording him an opportunity of hearing in accordance with law. If the counsel appearing for the appellant pleaded no instructions, no fault of procedural or substantial violation could be attributed to the court. The blame for such attitude would lie on none else but the appellants or the persons pursuing appeal on their behalf. The High Court took every precaution and ensured proper hearing to the appellants before it passed the impugned judgment. Thus, we have no hesitation in rejecting this contention. The remaining three contentions raised on behalf of the appellant can be discussed together in order to avoid repetitive discussion as they are interlinked with appreciation of evidence. According to the prosecution, the deceased Devendra was murdered by three accused, to which his brother Bhupal Chand, prosecution witness 1, Rajendra Singh, prosecution witness 2, and Prem Ram, prosecution witness 3 were eyewitnesses. They were coming from the marriage, and in torchlight, they saw the accused committing the crime. Prosecution witness 1 has fully supported the case of the prosecution and has stated that Jeevan was carrying a knife and Kamal and Dalit were carrying dandas. There were heated exchange of words between them, and thereafter Kamal caught hold of Devendra while Jeevan stabbed 3 to 4 times in the stomach of Devendra. On seeing this, prosecution witness 1 raised an alarm, and then witnesses Rajendra Singh and Prem Ram came to the place of occurrence. Upon their coming, the accused persons ran away. The deceased was taken to the hospital where he collapsed. In the cross-examination, prosecution witness 1 also stated that crime scene was about 100 steps away from the venue of marriage of Puran Chandra, and there was no light in the passage. According to prosecution witness 2, Rajendra Singh, they were sitting in the house of Shyam Lal and talking when they heard the noise coming from the hut of Nathuram, prosecution witness 2 and prosecution witness 3. Thereafter reached the place of occurrence. In the torchlight, they claimed to have seen the accused person committing the crime, including the fact that Jeevan was carrying knife and that Jeevan stabbed the deceased. According to him, when they challenged the accused person ran away. On similar lines is the statement of prosecution witness 3. The first question that arises for consideration is whether the presence of these three witnesses in and around the place of occurrence is so very doubtful that their statement should be disbelieved. The answer to this question has to be in the negative. It is, it is an undisputed case before us that there was a marriage in the house of Puran Chandra, and all the three witnesses had gone to attend the marriage. Prosecution witness 1 was accompanying the deceased. When they were returning from the marriage, the incident occurred near the place of Nathura. It is not unbelievable that village people, persons would attend a marriage and sit down at somebody's place to chat. Thus, the presence of prosecution witness 2 and prosecution witness 3 at the place of Shyamlal can hardly be doubtful. Prosecution witness 1 would be accompanying the deceased as he was his brother. We are unable to see any merit in the contention and the reasons for which the court can come to the conclusion that the presence of these witnesses at the place of occurrence was doubtful.
Wait, Shilu, wait.
Have it
Wait. Thank you so much. Very well read. This was a murder trial. There are many things discussed. Few things I would like to bring to your notice, that there was delay, then there was marriage party around, and the court was looking for whether there are independent witnesses or not. What happened at the end of the trial is not very consequent to us. The reason being, I am not the one who is going through the trial, and it is not. But what we can learn from the other people's trial by reading the judgment, that these are the mistakes we should not do, and what are the grounds taken by the appellant's counsel or accused counsel. Here there was a marriage party. Also, there were a lot many people. There was also inordinate delay in filing the FIR. What was the reason behind it? Court was trying to find out all that, and the appellant's lawyer has defense lawyer has put up all these reasons before the court. So as a defense lawyer, you should be able to do it. And this can be done only, or you will learn it only when you keep on reading this kind of judgments. Now, next we are moving on about the drafting of written statement. And this is something totally a pure, simple, civil nature. But let me tell you, drafting of written statement actually easy, but a very important part of any civil proceedings, because a lot depends on what you write in the written statement. Suppose there is a petition filed by the husband, and he has taken lot many grounds, he has given all the facts, and which are totally against, of course it's a divorce petition, it is all the facts are against the woman. Now you have to bring a story which through which you can rebut the husband's allegation, also put forth your case. Now, when I see written statement, sometimes people just go in denial. Yes, no, I have not beaten her, or whatever they have said, they will always just refuse and rebut the all the allegation. No, that is not the way to do it. You cannot refute just the allegation. You have to answer what is actually taken place, what was the real story, what was the real facts. And if you do not take these things in your written statement and do not provide any evidence, by maybe it may be documentary evidence, it may be ocular evidence, it may be through a witness which knows both the parties, and if you don't give list of witnesses, or you make a reference in your written statement or your written pleadings, then definitely you cannot bring those witnesses later on. You cannot go in the cross examination. That's why it is very important, whenever you draft the written statement, try to read the plaintiff's plaint or the petition carefully and answer that with thorough, deep study with the clients. And I always say the client knows his or her case better. That's why please try to get the answers in writing, written instruction from the client. And nowadays we have email, WhatsApp. It is actually very easy. We need not call the clients to the office and meet somewhere to discuss what has happened. You should always call for the history of the client and also the explanation to the plaintiff's petition, plaintiff suit, or the divorce petition or divorce suit, whatever it is. It may be also a criminal matter when 125 CRPC petition is also there. There also you have to file a reply. It is not called written statement. It is reply to the CRPC application. Then also you need to get all the answers. And the first rule I would say, start reading the judgments on the written statement. This will give insight actually how to be draft written statement. It is very easy, but then it requires lot of studies. Secondly, when you write a written statement, also support it with the facts. Don't just give your story. Support with the facts, support with the witnesses, support with the documentary evidence. The other side who is going to read your written statement, they should be taken by the surprise and also the threat that you are going to give a tough fight. If you don't give your written statement very strongly, then definitely the opposite person will say that they don't have a very good case. This is very important that you file the written statement with lot of information. Let it be in detail. It's so completely fine. Written statement may be more than the divorce petition or the plaint of the plaintiff, but you should provide all the information, because later on the court may not take the evidence which is not reflected, or any reference which is not reflected in written statement. The opposite lawyer, if he is smart, he will ask, there is no reference of this in your written statement, you cannot travel beyond pleadings. Always in cross examination you can travel beyond pleadings, but when you are putting up your case from defense side, or from the side of uh, the respondent, then you need to have a lot of information, or also your written statement should support that. If there is no reference in your written statement, it will be really difficult to get those witnesses also to support any documents or the call. It is possible you may not be having the documents, but give a reference and find out with in whose custody those documents, and from whom. By issuing summons or notices, you can get those bankers documents or any other property document. So always remember that written statement should be supported by documents. People always file the petition with lot of list of documents, but when they file written statement, they do not make list of documents. That is completely fine if you are not ready with it, but at least make an effort to refer the documents and say, as and when at the time of evidence I will produce, respondent undertake to produce these documents. If you are unable to produce, then also court will find out that there was such document, and you can always say this document is in the custody of the petitioner or the plaintiff. So always remember your return statement should have the complete detail. I have found out a judgment which says it will very most important, I would say, that what are the contentions which return statement should have. Wait, I will be sharing it. This is judgment, the state of Gujarat and another versus Valiban Savis by. It's a labor court judgment, but let's go. I'll read para 16. The labor court has considered the affidavit and cross-examination of the respondents, workmen, and come to the conclusion that petitioner has not challenged the evidence of the respondents, workmen, in respect to the continued service, presence mark in muster roll, and payment of wages has been made to respond workmen. In written statement, only contention was raised that for that period when respondents are not working and not in service, they were not entitled for any amount of wages. The written statement has been produced by the petitioner before this court, which is at page 40. There is no answer given by the petitioner except a document and legal condition para 12 raised by the petitioner, where no averment has been made to deny the factual aspect which has been made by respondent workmen in their statement of claim. See how written statement helps the laborers here. The government made a submission of claim if it is not denied in written statement. It amounts to admission of that fact accepted by the petitioner. The government made in the submission or claim if it is not denied in written statement. See, if you don't deny in written statement, It amounts to admission. Suppose a statement is made of a claim or a submission in the petition filed by the laborer. And here, when written statement you don't deny, it is an admission. Secondly, I'll go to the paragraph 22. Learned AGP, Mr. Makwana, submitted that contention of delay has been raised in written statement and contention that petitioner is not industry was also raised in the written statement, but Labour Court has not considered it. From the entire award, nowhere such contention was raised before the Labour Court by the petitioner. Merely raising